Question 1. The risk matrix shows a significant potential for client dissatisfaction and ethical breaches if end-of-life care preferences are not fully understood and respected. An elder law attorney in Alabama is working with a client who expresses a strong aversion to hospice care, believing it signifies giving up on life and will lead to abandonment. The client has a progressive, incurable illness and would benefit from palliative symptom management. What is the most appropriate course of action for the attorney to take? Option A. Document the client's refusal of hospice care and proceed with other legal matters without further exploration of their end-of-life care options to avoid imposing personal beliefs on the client. Option B. Immediately refer the client to a hospice agency, explaining that it is the standard of care for their condition and that their fears are likely unfounded, assuming the agency can address their concerns. Option C. Engage in a detailed, client-centered conversation to understand the specific fears and misconceptions driving the client's aversion to hospice. Explain the principles of palliative and hospice care in Alabama, focusing on comfort and dignity, and explore how these services can be adapted to address the client's concerns and align with their values. Option D. Advise the client that hospice care is a medical necessity for symptom management and that their personal beliefs about giving up are not relevant to the medical benefits they are entitled to under Alabama law. The correct answer is C. Engage in a detailed, client-centered conversation to understand the specific fears and misconceptions driving the client's aversion to hospice. Explain the principles of palliative and hospice care in Alabama, focusing on comfort and dignity, and explore how these services can be adapted to address the client's concerns and align with their values. Explanation. Scenario analysis. This scenario presents a common and ethically complex challenge in elder law within Alabama. The professional is tasked with navigating a client's deeply held personal beliefs and wishes regarding end-of-life care against the practical realities and available resources of palliative and hospice care. The challenge lies in ensuring the client's autonomy is respected, while also providing accurate information about their options and the implications of their choices, all within the framework of Alabama law and ethical practice. The professional must balance advocacy for the client's expressed desires with the duty to inform and ensure understanding, particularly when those desires might limit access to potentially beneficial services. Correct approach analysis. The best professional approach involves a thorough, client-centered discussion that prioritizes understanding the client's values and fears driving their reluctance towards hospice care. This includes actively listening to their concerns, explaining the core principles of palliative and hospice care in Alabama, emphasizing comfort, dignity, and symptom management rather than solely cure, and exploring their specific objections. The professional should then collaboratively explore how hospice services can be tailored to align with the client's wishes, perhaps by focusing on in-home services or specific aspects of care they find acceptable. This approach respects client autonomy, fulfills the duty of informed consent, and seeks to find a solution that honors the client's preferences within the available legal and medical framework in Alabama. It directly addresses the client's expressed concerns and seeks to bridge the gap between their understanding and the reality of available support. Incorrect approaches analysis. One incorrect approach involves dismissing the client's concerns about hospice as simply a misunderstanding and proceeding with a standard referral without addressing the root cause of their reluctance. This fails to respect client autonomy and the principle of informed consent, as it does not ensure the client truly understands their options or that their specific objections have been heard and addressed. Another incorrect approach is to overemphasize the medical benefits of hospice without acknowledging or validating the client's emotional or philosophical objections, potentially alienating the client and making them less receptive to any form of palliative support. Finally, an approach that pressures the client into accepting hospice care against their deeply held beliefs, even with good intentions, violates the ethical imperative to uphold client self-determination and can lead to a breakdown of trust and a failure to provide appropriate, client-preferred care. Professional reasoning. Professionals in Alabama elder law should approach such situations by first establishing a foundation of trust and open communication. The decision-making process should be guided by the client's expressed values and preferences, with the professional acting as an informed guide. This involves 1. Active listening and empathy, understanding the client's perspective and validating their feelings. 2. Comprehensive information provision, clearly explaining all available options, including the nuances of palliative and hospice care in Alabama and their potential benefits and limitations. 3. Collaborative problem solving, working with the client to identify solutions that align with their wishes and values, even if it requires creative application of available services. 4. Respect for autonomy, ultimately, ensuring the client makes informed decisions about their care, free from coercion or undue influence. Question 2. Strategic planning requires an elder law attorney in Alabama to advise a client who is exhibiting some signs of cognitive decline, but insists on transferring a significant portion of their assets to a family member who is present and actively participating in the meeting. The attorney suspects the client may be susceptible to undue influence. What is the most ethically sound and legally prudent course of action for the attorney to take? Option A. Immediately halt all discussions and advise the client that they lack the capacity to make such a decision, recommending that the family member take over financial management. Option B. Focus primarily on satisfying the family member's concerns about the client's financial future, as they are likely the most informed about the client's needs and are present to advocate for them. Option C. Conduct a thorough assessment of the client's capacity to understand the transaction and its implications. Document all findings and discussions, explore the client's motivations independently, and consider involving a neutral third party or seeking a capacity evaluation if concerns persist, while ensuring the client's wishes are respected if they possess the requisite capacity. Option D. Proceed with the asset transfer as requested by the client, as their expressed desire is paramount, and the family member's presence indicates their support for the client's decision. The correct answer is C. Conduct a thorough assessment of the client's capacity to understand the transaction and its implications. Document all findings and discussions, explore the client's motivations independently, and consider involving a neutral third party or seeking a capacity evaluation if concerns persist, while ensuring the client's wishes are respected if they possess the requisite capacity. Explanation. This scenario presents a professional challenge because the elder law attorney must navigate the complex interplay between a client's expressed wishes, their declining capacity, and the legal framework designed to protect vulnerable adults in Alabama. The attorney's duty is to uphold the client's autonomy while also ensuring their legal actions are sound and do not exploit or endanger the client. This requires a delicate balance and a thorough understanding of Alabama's laws regarding capacity and undue influence. Best professional approach involves a multifaceted strategy that prioritizes the client's current and future well-being within the bounds of Alabama law. This includes conducting a comprehensive assessment of the client's understanding and voluntariness, documenting all interactions meticulously, and exploring less restrictive alternatives to immediate asset transfer if capacity is questionable. Consulting with trusted family members, with the client's explicit consent, can provide valuable context, but the ultimate decision-making authority rests with the client, provided they have the requisite capacity. This approach aligns with the ethical obligations of an attorney to act in the client's best interest, maintain confidentiality, and avoid engaging in or facilitating fraudulent or illegal activity, as guided by the Alabama State Bar Rules of Professional Conduct. An approach that solely focuses on fulfilling the client's immediate request, without a thorough capacity assessment risks facilitating a transaction that could be later challenged as a result of undue influence or exploitation, violating the attorney's duty of care and potentially exposing the client to financial harm. This failure to adequately investigate the client's understanding and the circumstances surrounding the request is a significant ethical lapse. Another unacceptable approach involves proceeding with the asset transfer based solely on the client's stated desire, without any attempt to verify their understanding of the implications, or to assess for potential undue influence from the family member present. This bypasses the attorney's responsibility to ensure the client is making informed decisions, and could lead to a situation where the client's assets are transferred under duress or without full comprehension, contravening the principles of client advocacy and protection. Furthermore, an approach that prioritizes the family member's perceived needs over the client's expressed wishes and legal capacity, even if done with the intention of appeasing the family, is ethically unsound. The attorney's primary allegiance is to the client, and any actions taken must be for the client's benefit and in accordance with their informed consent and legal capacity. The professional reasoning process for such situations should begin with a clear understanding of the client's objectives. This is followed by a rigorous assessment of the client's mental capacity to understand the nature and consequences of the proposed action, as well as an evaluation of any potential undue influence. Documentation of this assessment and the client's decision-making process is paramount. If capacity is uncertain or undue influence is suspected, the attorney must explore less restrictive alternatives, seek further expert evaluation if necessary, and communicate transparently with the client about the risks and benefits of their proposed course of action. Question 3. The performance metrics show a need for enhanced client education regarding tax implications in estate planning. An elder law attorney in Alabama is advising a client who wishes to update their will and trusts. The client has significant assets, including real estate and investment portfolios, and expresses a desire to minimize the tax burden on their heirs. What is the most prudent course of action for the attorney to ensure the client's wishes are met while adhering to professional standards in Alabama law? Option A. Conduct a comprehensive review of the client's current estate plan and assets, discuss potential federal and Alabama estate, gift and income, tax implications of various planning strategies, and propose tailored solutions that align with the client's goals and capacity. Option B. Focus solely on strategies to reduce federal estate taxes, assuming that minimizing this single tax will automatically address all other potential tax concerns for the heirs. Option C. Implement aggressive, complex trust structures and gifting strategies to achieve maximum tax reduction, without a thorough assessment of the client's capacity to understand or manage these arrangements. Option D. Immediately proceed with drafting amendments to the will and trusts based on the client's stated desire to minimize taxes, without a detailed analysis of specific tax liabilities or alternative strategies. Correct answer is A. Conduct a comprehensive review of the client's current estate plan and assets, discuss potential federal and Alabama estate, gift and income, tax implications of various planning strategies, and propose tailored solutions that align with the client's goals and capacity. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an elder law attorney in Alabama to navigate the complex interplay of estate planning, tax implications, and the specific needs of an aging client with potential cognitive decline. The attorney must balance the client's stated wishes with the need to ensure the plan is legally sound, tax efficient, and protects the client from undue influence or future incapacity. The potential for significant tax liabilities necessitates a thorough understanding of Alabama and federal tax laws as they apply to estates and trusts. Correct approach analysis. The best professional practice involves a comprehensive review of the client's existing estate plan and current assets, followed by a detailed discussion of potential tax implications under Alabama and federal law. This includes exploring strategies for minimizing estate taxes, gift taxes, and income taxes on inherited assets, considering the client's specific financial situation and family dynamics. The attorney should then propose tailored solutions, such as utilizing trusts, gifting strategies, or charitable contributions, all while ensuring the client has the capacity to understand and consent to these changes. This approach prioritizes the client's best interests, legal compliance, and tax efficiency, aligning with ethical duties of competence and diligence. Incorrect approach is analysis. One incorrect approach is to proceed with amending the estate plan based solely on the client's immediate, potentially unexamined, request without thoroughly assessing the tax consequences. This fails to meet the duty of competence and diligence, as it ignores significant potential liabilities that could diminish the inheritance for beneficiaries. It also risks overlooking opportunities for tax savings that a competent attorney should identify. Another incorrect approach is to focus exclusively on minimizing estate taxes without considering the client's overall financial goals or the potential impact on beneficiaries' income tax situations. This narrow focus can lead to a plan that is tax efficient in one area but detrimental in others, failing to provide holistic advice. It also neglects the ethical obligation to consider the client's broader objectives. A third incorrect approach is to implement aggressive tax avoidance strategies without adequately assessing the client's capacity or the potential for future challenges to the plan. This could involve complex trust structures or gifting that, while tax advantageous on paper, may be difficult for the client to understand or manage, or could be vulnerable to legal disputes if the client's capacity is questioned later. This approach risks violating ethical duties related to client understanding and protection, professional reasoning, professionals should adopt a systematic approach. First, conduct a thorough client intake and review existing documents. Second, identify the client's goals and concerns. Third, analyze the current asset structure and potential tax liabilities under relevant state, Alabama, and federal laws. Fourth, explore various planning strategies, evaluating their tax implications, legal feasibility, and alignment with client goals. Fifth, assess client capacity to understand and consent to proposed changes. Finally, document all discussions, recommendations, and decisions thoroughly. Question 4. The assessment process reveals that an elderly client in Montgomery, Alabama, wishes to establish a durable power of attorney. While the client expresses a clear desire to grant broad financial and healthcare decision-making authority to their trusted child, there are subtle but noticeable signs of recent memory loss and occasional confusion during conversations. What is the most prudent and legally sound approach to ensure the validity and enforceability of the durable power of attorney under Alabama law? Option A. Rely on a verbal agreement between the client and the proposed agent, documented only in personal notes, that outlines the intended scope of authority, in addition to the written durable power of attorney. Option B. Proceed with executing the durable power of attorney based on the client's verbal assurances and the family's belief that the client understands the document, without seeking an independent professional capacity assessment. Option C. Draft the durable power of attorney with extremely broad and vague language regarding the agent's powers to provide maximum flexibility, assuming the agent will act in the client's best interest. Option D. Obtain a formal, written assessment of the client's cognitive capacity from a qualified medical professional, such as a geriatric psychiatrist or neurologist, to document their ability to understand the nature and effect of the durable power of attorney at the time of execution, and ensure the document clearly specifies the granted powers. The correct answer is D. Obtain a formal, written assessment of the client's cognitive capacity from a qualified medical professional, such as a geriatric psychiatrist or neurologist, to document their ability to understand the nature and effect of the durable power of attorney at the time of execution, and ensure the document clearly specifies the granted powers. Explanation. The assessment process reveals a common yet complex scenario in Alabama elder law, navigating the creation and implementation of a durable power of attorney (DPOA) when an individual's cognitive capacity is in question. This situation is professionally challenging because it requires balancing the principal's right to self-determination with the need to protect them from potential exploitation or undue influence, all while adhering strictly to Alabama's statutory requirements for DPOA. The agent's duties are fiduciary, demanding utmost good faith and loyalty, which can be tested when the principal's wishes become ambiguous due to declining mental faculties. The best approach involves a thorough, documented assessment of the principal's capacity at the time of execution, ideally conducted by a qualified medical professional, and ensuring the DPOA document itself clearly articulates the principal's intentions and the agent's powers. This aligns with Alabama Code Section 26-1-2, which governs DPOA and emphasizes the principal's intent. A properly executed DPOA, with clear capacity documentation, provides the strongest legal foundation for the agent to act, minimizing the risk of challenges based on lack of capacity or improper execution. This proactive documentation serves as evidence of the principal's understanding and voluntary agreement to the terms of the DPOA. An incorrect approach would be to proceed with executing a DPOA based solely on the principal's verbal assurances without a formal capacity assessment, especially if there are observable signs of cognitive impairment. This fails to meet the implicit requirement of informed consent and could render the DPOA invalid under Alabama law if challenged, as the principal may not have had the mental capacity to understand the document's implications. Another incorrect approach is to draft a DPOA with overly broad or ambiguous powers that could be easily misinterpreted or exploited by the agent. Alabama law expects clarity in the powers granted. Such ambiguity increases the risk of the agent exceeding their authority or acting in a manner not truly reflective of the principal's wishes, potentially leading to legal disputes and breach of fiduciary duty. Finally, an incorrect approach would be to rely on informal agreements or understandings between the principal and the agent outside of the written DPOA document. Alabama's DPOA statutes require the powers to be clearly defined in writing. Oral agreements are not legally binding in this context and can create significant confusion and legal challenges regarding the scope of the agent's authority. Professionals should employ a decision-making framework that prioritizes clear, documented evidence of the principal's capacity and intent. This involves engaging with the principal directly, observing their understanding, and recommending a formal capacity evaluation when appropriate. Thoroughly reviewing the DPOA document with the principal to ensure they comprehend each provision and power granted is crucial. Maintaining meticulous records of all interactions, assessments, and communications is essential for demonstrating compliance with legal and ethical obligations. Question 5. Which approach would be most appropriate for a healthcare provider in Alabama when a patient with a valid advance directive is admitted with a critical condition, and the advance directive clearly outlines preferences for end-of-life care but does not explicitly address the current emergent situation? Option A. Proceed with aggressive life-sustaining treatment based on the medical team's judgment. The advance directive does not specifically cover the emergent circumstances. Option B. Make independent medical decisions that the provider believes are in the patient's best interest, even if they appear to contradict the general spirit of the advance directive. Option C. Review the existing advance directive for any relevant provisions and consult with the designated healthcare agent to interpret the patient's wishes in light of the current emergent situation. Option D. Delay all medical interventions until all distant family members can be contacted and consulted, regardless of their legal standing as healthcare agents. The correct answer is C. Review the existing advance directive for any relevant provisions and consult with the designated healthcare agent to interpret the patient's wishes in light of the current emergent situation. Explanation: this scenario is professionally challenging because it requires balancing the patient's immediate medical needs with their previously expressed wishes and the legal framework governing advance directives in Alabama. The healthcare provider must act swiftly to ensure appropriate care while respecting the patient's autonomy and the legal validity of their advance directive. Careful judgment is required to avoid both overstepping the bounds of the advance directive and failing to provide necessary medical intervention. The best approach involves a thorough review of the existing advance directive to determine the scope of the patient's instructions and the designated healthcare agent's authority. This approach is correct because Alabama law, specifically the Alabama Advanced Health Care Directive Act, recognizes the legal validity of advance directives and grants significant authority to healthcare agents. By consulting the document and the agent, the provider ensures that the patient's wishes are honored and that the agent can fulfill their legal responsibilities. This upholds patient autonomy and adheres to the statutory requirements for respecting advance directives. An approach that involves disregarding the advance directive and proceeding solely based on the current medical team's assessment is professionally unacceptable. This fails to respect the patient's right to self-determination, which is a cornerstone of medical ethics and is legally protected by Alabama's advance directive laws. It also bypasses the designated healthcare agent, undermining their legal authority. Another professionally unacceptable approach is to delay necessary medical treatment while attempting to locate distant family members who are not designated as healthcare agents. This can lead to a deterioration of the patient's condition and potentially violate the duty to provide timely and appropriate care. Alabama law prioritizes the instructions within the advance directive and the authority of the appointed agent over the input of individuals without legal standing in healthcare decision-making. Finally, an approach that involves unilaterally making decisions that contradict the clear instructions in the advance directive, even with good intentions, is ethically and legally flawed. This demonstrates a failure to understand or respect the legal weight of the advance directive and the patient's expressed wishes, potentially leading to legal repercussions and a breach of trust. Professionals should employ a decision-making framework that begins with identifying and reviewing any existing advance directive. If an advance directive exists, the next step is to identify and consult with the designated healthcare agent. If the directive is unclear or the agent is unavailable, the provider should consult the Alabama Advanced Health Care Directive Act for guidance on next steps, which may involve seeking legal counsel or following statutory hierarchies for surrogate decision makers. Question 6. Investigation of a conservator's duties in Alabama. An elder ward's family member reports that the ward, prior to their incapacitation, repeatedly expressed a strong desire to sell a specific parcel of real estate they owned, believing it would provide them with greater financial security in their later years. The conservator, appointed by an Alabama probate court, is now considering whether to proceed with selling the property based on this information. As the property is currently underutilized and could generate income, what is the most appropriate course of action for the conservator to take in this situation? Option A. Refuse to consider selling the property and inform the family member that the ward's current incapacity prevents any action based on past statements. Option B. Ignore the family member's report and continue to manage the property as is, since the ward is currently incapacitated and cannot provide direct consent. Option C. Proceed with selling the property immediately, as the family member's report clearly indicates the ward's prior wishes, and the sale would likely benefit the estate. Option D. Petition the Alabama probate court for guidance and approval regarding the sale of the property, presenting all gathered information about the ward's prior expressed wishes and the potential benefits of the sale. The correct answer is D. Petition the Alabama probate court for guidance and approval regarding the sale of the property, presenting all gathered information about the ward's prior expressed wishes and the potential benefits of the sale. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a conflict between the stated wishes of an incapacitated elder and the perceived best interests of their estate, as interpreted by a family member. The core difficulty lies in balancing the elder's autonomy, even if diminished, with the fiduciary duties of a conservator and the legal requirements for managing an estate in Alabama. A conservator must act in the ward's best interest, but this must be balanced against respecting the ward's prior expressed wishes and preferences to the extent possible, and adhering strictly to Alabama probate law. Correct approach analysis. The best professional practice involves a conservator diligently investigating the elder's prior expressed wishes regarding their property, and then petitioning the Alabama probate court for guidance on how to proceed. This approach is correct because Alabama law, specifically the Alabama Uniform Probate Code, ALA, Code Section 26-2A101 et seq., emphasizes that a conservator's primary duty is to the ward's welfare and estate. However, it also recognizes the importance of the ward's autonomy and prior intentions. By seeking court approval for actions that deviate from a ward's known prior wishes, the conservator demonstrates good faith, transparency, and adherence to legal procedures, ensuring that decisions are made in the ward's best interest as defined by the court, which acts as the ultimate arbiter. This process protects both the ward and the conservator from potential liability. Incorrect approach is analysis. One incorrect approach involves the conservator unilaterally selling the property based on the family member's assertion of the elder's past statements and the perceived benefit to the estate. This is professionally unacceptable because it bypasses the legal requirement for court oversight in significant financial decisions concerning a ward's estate. Alabama probate law requires court approval for the sale of real property by a conservator, ALA, Code Section 26-2A116. Acting without this approval constitutes a breach of fiduciary duty and a violation of statutory requirements, potentially exposing the conservator to personal liability and invalidating the sale. Another incorrect approach is for the conservator to ignore the family member's information and proceed with managing the property without any attempt to ascertain or honor the elder's prior wishes, simply because the elder is now incapacitated. This is professionally unacceptable, as it fails to uphold the principle of respecting the ward's autonomy and prior intentions to the greatest extent possible, which is a guiding ethical and legal consideration in conservatorship. While the elder is incapacitated, their past expressed desires are relevant to determining their best interests. A further incorrect approach is for the conservator to refuse to engage with the family member or consider their input, citing the elder's current incapacity. This is professionally unacceptable because it demonstrates a lack of diligence in gathering information relevant to the ward's best interests and a failure to communicate effectively with interested parties. A conservator has a duty to be informed and to act prudently, which includes considering all available information and perspectives that might illuminate the ward's needs and preferences. Professional reasoning. Professionals in Alabama should employ a decision-making framework that prioritizes understanding the ward's current needs and circumstances, diligently investigating their prior wishes and preferences, and strictly adhering to the Alabama Uniform Probate Code. When faced with potential conflicts or significant decisions, the framework dictates seeking guidance from the probate court. This involves clear documentation of all actions, communications, and investigations, and a commitment to transparency and accountability throughout the conservatorship. The ultimate goal is to act in the ward's best interest while respecting their dignity and prior autonomy as much as legally and practically feasible. Question 7. Assessment of an individual's testamentary capacity in Alabama requires a nuanced understanding of how legal standards have evolved. Considering the historical development of elder law in Alabama, which of the following best reflects the modern legal interpretation of testamentary capacity, acknowledging its historical roots? Option A. Testamentary capacity in Alabama is assessed using a universal standard applicable across all U.S. states, without specific consideration for Alabama's legal history. Option B. Testamentary capacity in Alabama is solely determined by a recent medical diagnosis of cognitive impairment, regardless of the testator's functional understanding of their estate. Option C. Testamentary capacity in Alabama is primarily determined by whether the testator can recognize their immediate family members and their home. Option D. Testamentary capacity in Alabama is assessed by the testator's ability to understand the nature and extent of their property, the natural objects of their bounty, and the disposition they are making of their property, a standard that has evolved from earlier, less comprehensive interpretations. Correct answer is D. Testamentary capacity in Alabama is assessed by the testator's ability to understand the nature and extent of their property, the natural objects of their bounty, and the disposition they are making of their property, a standard that has evolved from earlier, less comprehensive interpretations. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the evolving legal landscape of elder law in Alabama, specifically concerning the historical shift in how testamentary capacity is assessed. A professional must understand the foundational principles that guided earlier legal interpretations and how modern jurisprudence, influenced by advancements in medical understanding and societal values, has reshaped these standards. Failure to grasp this historical development can lead to misinterpretations of current Alabama law, potentially impacting the validity of wills and the protection of vulnerable individuals. Correct approach analysis. The best professional approach involves recognizing that historical legal standards for testamentary capacity in Alabama, while foundational, have been significantly refined. Early Alabama jurisprudence often focused on a more rudimentary understanding of mental competence, sometimes equating it with the ability to recognize immediate family or property. Modern Alabama law, however, reflects a more nuanced understanding, emphasizing the testator's ability to understand the nature and extent of their property, the natural objects of their bounty, and the disposition they are making of their property, even if they suffer from some cognitive impairment. This approach acknowledges the historical context while prioritizing the current, more sophisticated legal interpretation prevalent in Alabama. Incorrect approaches analysis. One incorrect approach would be to solely rely on the most rudimentary historical interpretations of testamentary capacity in Alabama, such as a simple ability to recognize immediate family members. This fails to account for the evolution of legal standards and the more comprehensive understanding of mental capacity required by contemporary Alabama law. Another incorrect approach is to apply a generic, non-jurisdiction-specific standard of testamentary capacity without considering the specific historical and current legal precedents within Alabama. This overlooks the unique development of elder law within the state. Finally, an approach that dismisses the historical development entirely and focuses only on the most recent case law without understanding the foundational principles that led to those changes would also be flawed, as it might miss subtle but important nuances in the legal reasoning. Professional reasoning. Professionals should employ a decision-making framework that begins with identifying the specific jurisdiction, Alabama, and the relevant legal area, elder law, specifically testamentary capacity. They should then research the historical development of testamentary capacity standards within Alabama, tracing the evolution from earlier, simpler tests to the current, more comprehensive legal tests. This historical understanding should then be integrated with a thorough analysis of current Alabama statutes and case law. When presented with a specific case, professionals must apply the current Alabama legal standard, informed by its historical context, to the facts at hand, ensuring that the assessment of testamentary capacity is both legally sound and ethically responsible. Question 8. Benchmark analysis indicates that a financial advisor in Alabama is assisting an elderly client who wishes to make a significant gift to her children. The client's children are present during all meetings and are actively involved in discussing the terms of the gift, expressing strong opinions about how the funds should be managed. The client appears agreeable to her children's suggestions. What is the most appropriate course of action for the financial advisor to ensure the client's best interests are protected and that the transaction is legally sound under Alabama law? Option A. Proceed with facilitating the gift as requested by the client, relying on the presence of the children to ensure the client is not acting alone and that all parties are aware of the transaction. Option B. Advise the client to seek independent legal counsel to review the proposed gift and confirm her understanding and voluntary intent, while also documenting all discussions and the client's stated wishes. Option C. Urge the client to make a decision quickly to finalize the gift before any potential changes in her circumstances or the family's opinions, while noting the children's input. Option D. Inform the client that due to the children's active involvement, the advisor cannot proceed with the transaction and recommend the client reconsider the gift entirely. The correct answer is B. Advise the client to seek independent legal counsel to review the proposed gift and confirm her understanding and voluntary intent, while also documenting all discussions and the client's stated wishes. Explanation: this scenario is professionally challenging because it requires navigating the complex interplay between an elder's expressed wishes, the potential for undue influence, and the legal framework designed to protect vulnerable adults in Alabama. The fiduciary duty owed to the client necessitates a careful balance between respecting autonomy and ensuring the validity of decisions, especially when family members are involved and stand to benefit. The best professional approach involves a thorough understanding and application of Alabama's laws concerning elder abuse, neglect, and exploitation, particularly the Alabama Elder Abuse and Neglect Act. This approach prioritizes obtaining independent legal counsel for the client to ensure their decision-making capacity is assessed and that any transactions are free from coercion. It also involves documenting all interactions and communications meticulously, creating a clear record of the client's informed consent and the absence of undue influence. This aligns with the ethical obligations to act in the client's best interest and to prevent harm. An incorrect approach would be to proceed with the transaction based solely on the family's assurances and the client's verbal agreement without independent verification of capacity or legal counsel. This fails to address the potential for exploitation and violates the duty to ensure the client's decisions are truly their own and legally sound. Another incorrect approach would be to dismiss the family's involvement entirely and refuse to facilitate any transaction, even if the client is fully capable and wishes to proceed. This could be seen as overstepping professional boundaries and infringing on the client's right to make their own financial decisions, provided they are competent and acting voluntarily. Finally, an approach that involves pressuring the client to make a decision quickly to appease the family, without adequate time for reflection or legal review, would be ethically and legally unsound, as it could inadvertently facilitate undue influence. Professionals should employ a decision-making framework that begins with a clear assessment of the client's capacity and the circumstances surrounding their decisions. This includes identifying potential conflicts of interest and red flags for undue influence. The next step is to consult relevant state statutes, such as the Alabama Elder Abuse and Neglect Act, to understand legal protections and requirements. Seeking independent legal counsel for the client is paramount when significant financial decisions are involved, especially with family involvement. Thorough documentation of all steps, communications, and decisions is crucial for accountability and protection. Question 9. The performance metrics show a pattern of increased inquiries regarding the legal capacity of elderly clients in Alabama who are considering significant financial transactions or changes to their estate plans. A financial advisor in Birmingham, Alabama, has a long-standing client, Mrs. Gable, aged 85, who wishes to gift a substantial portion of her assets to her grandchildren. The advisor notes that Mrs. Gable sometimes misremembers recent conversations and occasionally repeats herself, but she is articulate, engaged in the discussion about the gift, and clearly expresses her desire to provide for her grandchildren before her passing. The advisor is concerned about Mrs. Gable's capacity to understand the long-term implications of such a significant gift. What is the most appropriate course of action for the financial advisor to take in Alabama? Option A. Relies solely on the statement of Mrs. Gable's daughter, who expresses concern about her mother's memory and urges the advisor to halt the transaction, without directly assessing Mrs. Gable's understanding herself. Option B. Conduct a thorough, documented assessment of Mrs. Gable's capacity to understand the specific transaction, gifting assets, clearly explain the implications of the gift, and explore less restrictive alternatives if capacity is genuinely in doubt, potentially involving a geriatric care manager or elder law attorney for a formal capacity evaluation. Option C. Proceed with the gift as requested by Mrs. Gable, assuming she has the right to do as she pleases with her assets without further inquiry into her understanding or capacity. Option D. Immediately advise Mrs. Gable that she likely lacks the capacity to make such a decision due to her age and occasional memory lapses, and recommend that her adult children take over her financial affairs. The correct answer is B. Conduct a thorough, documented assessment of Mrs. Gable's capacity to understand the specific transaction, gifting assets, clearly explain the implications of the gift, and explore less restrictive alternatives if capacity is genuinely in doubt, potentially involving a geriatric care manager or elder law attorney for a formal capacity evaluation. Explanation. The performance metrics show a concerning trend in the handling of cases involving potential diminished capacity among elderly clients in Alabama. This scenario is professionally challenging because it requires a delicate balance between respecting an individual's autonomy and ensuring their legal rights and financial well-being are protected when their capacity to make informed decisions may be compromised. Alabama law, particularly as it pertains to elder law and guardianship, places a high burden on professionals to act in the best interests of vulnerable adults while upholding their dignity and right to self-determination. The core ethical and legal imperative is to avoid exploitation and to facilitate decision-making that aligns with the client's wishes and best interests, even when those wishes might seem unwise to an observer. The best approach involves a thorough, multifaceted assessment of the client's capacity, documented meticulously, and involving appropriate professionals. This approach prioritizes gathering objective evidence of the client's cognitive abilities and understanding of the decisions they are making. It recognizes that capacity is decision-specific and can fluctuate. Engaging with the client directly, explaining options clearly, and observing their responses are crucial. If capacity is genuinely in doubt, the next step is to explore less restrictive alternatives to full guardianship, such as supported decision-making or limited guardianship, as mandated by Alabama law's preference for preserving autonomy. This aligns with the ethical duty of care and the legal framework designed to protect vulnerable adults. An approach that immediately assumes diminished capacity based on age or a single observation is ethically and legally flawed. It violates the presumption of capacity and can lead to unnecessary interventions that strip the individual of their autonomy. This can be seen as a form of ageism and can result in the client being subjected to guardianship proceedings without sufficient justification, causing emotional distress and financial burden. Another incorrect approach is to proceed with a transaction or legal action without adequately assessing capacity, especially when red flags are present. This risks facilitating a transaction that is not in the client's best interest or that they do not fully understand, potentially exposing them to financial exploitation or making decisions they will later regret. This failure to exercise due diligence and to act with reasonable care constitutes a breach of professional duty. Finally, an approach that relies solely on the opinion of a family member or caregiver without independent professional assessment is insufficient. While family input is valuable, it is subjective and can be influenced by various factors, including personal gain or misunderstanding of the client's true wishes. Alabama law requires a more objective and professional evaluation of capacity. Professionals should employ a decision-making framework that begins with a presumption of capacity. When concerns arise, the framework should mandate a structured assessment process. This includes direct communication with the client, clear explanation of the matter at hand, and observation of their comprehension and reasoning. If capacity remains in doubt, the next step is to consult with qualified professionals, e.g., geriatric psychiatrists, neurologists, or psychologists specializing in cognitive assessment, to obtain an objective evaluation. The results of these assessments should then guide the decision on whether less restrictive alternatives to guardianship are appropriate or if guardianship proceedings are indeed necessary. always prioritizing the client's expressed wishes and best interests as determined through a comprehensive and documented process. Question 10. The performance metrics show that Mrs. Gable, an 85-year-old resident of Mobile, Alabama, has accumulated $250,000 in savings and has a monthly income of $3,000. She requires ongoing skilled nursing care, which is projected to cost $8,000 per month. Mrs. Gable wishes to preserve as much of her savings as possible for her grandchildren, while ensuring her long-term care is fully covered by Alabama Medicaid. Her attorney is considering several trust structures. If Mrs. Gable's assets are placed into a revocable living trust, how much of her $250,000 savings would be considered a countable resource for Alabama Medicaid eligibility purposes, assuming the trust is funded solely with her assets and no other Medicaid planning has occurred? Option A, $25,000. Option B, $125,000. Option C, $250,000. Option D, $0. The correct answer is C, $250,000. Explanation. This scenario presents a professional challenge because it requires the elder law attorney to balance the client's immediate financial needs with the long-term implications of trust structures, particularly concerning eligibility for Alabama Medicaid benefits. The attorney must accurately calculate the financial impact of different trust types and understand how these structures interact with Alabama's specific Medicaid eligibility rules, which are governed by the Alabama Department of Human Resources, DHR. Miscalculating the financial impact or misapplying trust principles to Medicaid eligibility can lead to severe consequences for the elder client, including denial of essential long-term care benefits. The best professional approach involves establishing a special needs trust, S&T, for the benefit of the elder client. An S&T, when properly drafted and funded, allows assets to be held for the sole benefit of the beneficiary without being considered a countable resource for Medicaid eligibility purposes, provided it meets specific federal and state requirements, e.g., established by a parent, grandparent, guardian, or court, and containing provisions for the state to recoup remaining funds upon the beneficiary's death. This approach directly addresses the client's need for financial management and care while preserving their eligibility for critical government assistance. The attorney must ensure the trust is structured to comply with Alabama DHR regulations for S&Ts, specifically regarding the types of expenses the trust can cover and the remainder provisions. An incorrect approach would be to establish a revocable living trust and fund it with the client's assets. While a revocable trust offers flexibility and avoids probate, the assets within it are considered owned by the grantor and are therefore countable resources for Medicaid eligibility. This would likely lead to the client being ineligible for Alabama Medicaid benefits, failing to meet the primary objective of preserving access to care. Another incorrect approach would be to fund an irrevocable trust with the client's assets without careful consideration of the look-back period and specific Alabama Medicaid rules for irrevocable trusts. While some irrevocable trusts can be used for asset protection, improperly structured ones can trigger significant penalties, including a period of ineligibility for Medicaid benefits. The attorney must ensure the irrevocable trust is drafted to comply with Alabama's Medicaid rules, which often involve specific provisions for distributions and remainder beneficiaries, and that the funding does not violate the look-back period. Finally, an incorrect approach would be to advise the client to simply spend down their assets to meet the Medicaid resource limit without utilizing any trust planning. While asset spend-down is a common strategy, it may not be optimal if the client has specific needs that could be better met through a properly structured S&T, or if there are opportunities for strategic gifting or other asset protection measures that could preserve some wealth for heirs or other purposes, all while maintaining Medicaid eligibility. This approach fails to explore more sophisticated planning options that could achieve a better overall outcome for the client. The professional decision-making process should begin with a thorough understanding of the client's financial situation, their immediate and long-term care needs, and their estate planning goals. The attorney must then research and apply the specific Alabama Medicaid eligibility rules and relevant Alabama elder law statutes concerning trusts. A detailed financial analysis, including calculations of asset impact and potential benefit eligibility, is crucial. The attorney should then present the client with a range of legally permissible options, clearly explaining the advantages, disadvantages, and financial implications of each, with a strong recommendation for the approach that best aligns with the client's objectives and regulatory compliance. Question 11. The performance metrics show a growing demand for long-term care services among seniors in Alabama. A client, Mr. Henderson, age 82, is concerned about the significant cost of nursing home care and wishes to preserve as much of his estate as possible for his 2 adult children. He has a home valued at $300,000, $150,000 in a joint savings account with his wife, Mrs. Henderson, age 78, and $50,000 in a taxable investment account. Mr. Henderson anticipates needing nursing home care within the next 18-24 months. What is the most appropriate Medicaid planning strategy for Mr. Henderson, considering Alabama's specific laws and regulations? Option A. Suggests that Mr. Henderson purchase a new, more expensive vehicle and a vacation home, as these are typically considered exempt assets for Medicaid eligibility. Option B. Advise Mr. Henderson to immediately transfer all assets, including the home and savings, to his children to deplete his countable resources before applying for Medicaid. Option C. Recommend that Mr. Henderson spend down all available funds on non-essential personal items and luxury goods to reduce his countable assets. Option D. Conduct a comprehensive financial assessment and develop a plan that utilizes permissible Alabama Medicaid planning tools, such as establishing an irrevocable income-only trust for Mrs. Henderson's benefit, exploring spousal refusal options, and carefully planning any asset transfers or gifts in strict adherence to Alabama's look-back periods and asset exemption rules. The correct answer is D. Conduct a comprehensive financial assessment and develop a plan that utilizes permissible Alabama Medicaid planning tools, such as establishing an irrevocable income-only trust for Mrs. Henderson's benefit, exploring spousal refusal options, and carefully planning any asset transfers or gifts in strict adherence to Alabama's look-back periods and asset exemption rules. Explanation. This scenario presents a common challenge in elder law, balancing a client's desire to preserve assets for their family with the strict eligibility requirements for Alabama Medicaid benefits. The professional challenge lies in navigating the complex Alabama Medicaid rules, particularly regarding look-back periods and asset transfers, while ethically advising the client and ensuring their plan is legally sound and compliant. Misinterpreting these rules can lead to disqualification from essential long-term care benefits, causing significant financial hardship for the client and their family. The best approach involves a comprehensive assessment of the client's financial situation, including all assets and income, and a thorough understanding of their long-term care needs. This approach prioritizes a detailed review of Alabama's Medicaid eligibility rules, specifically focusing on the treatment of assets and transfers within the applicable look-back periods. It then involves developing a strategy that utilizes permissible Medicaid planning tools, such as spousal refusal, income trusts, if applicable and compliant with Alabama law, or carefully structured gifting within the statutory limits, to protect assets while still qualifying for benefits. This method is correct because it directly addresses the client's goals within the framework of Alabama Medicaid law, minimizing the risk of penalties and ensuring the client receives the care they need. It adheres to the ethical duty of competence and diligence by applying specific knowledge of Alabama's regulatory landscape. An approach that focuses solely on transferring assets to children without considering the Alabama Medicaid look-back period is incorrect. Its failure to account for the look-back period, which can result in a disqualification period for Medicaid benefits, directly violates Alabama Medicaid regulations and ethical obligations to provide accurate advice. Another incorrect approach would be to advise the client to spend down all assets on non-allowable expenses or to purchase assets that are not considered exempt under Alabama Medicaid rules. This strategy disregards the client's goal of asset preservation and fails to leverage permissible Medicaid planning techniques, potentially leading to unnecessary depletion of resources and ineligibility. Finally, an approach that relies on generic Medicaid planning advice without tailoring it to Alabama's specific statutes and administrative codes is professionally deficient. Alabama has unique rules regarding asset treatment, transfer penalties, and allowable planning strategies. Failing to apply these specific rules constitutes a failure of competence and diligence, potentially leading to severe negative consequences for the client. Professionals should employ a systematic decision-making process that begins with a thorough client intake and needs assessment. This should be followed by a detailed analysis of the client's financial picture in light of the specific Alabama Medicaid eligibility criteria. Legal research into current Alabama statutes, regulations, and relevant case law is crucial. The professional must then develop and present multiple compliance strategies, clearly explaining the pros and cons of each and the client's role in decision-making. Ongoing communication and documentation are essential to ensure the plan is executed correctly and remains compliant. Question 12. Risk assessment procedures indicate that Ms. Alina Gable, an 82-year-old client of your financial advisory firm in Mobile, Alabama, wishes to transfer a significant portion of her investment portfolio to her son, Mr. David Gable, who is present during the meeting and is actively directing the conversation and the proposed transaction. Ms. Gable appears hesitant and defers to her son's statements. What is the most appropriate immediate course of action for the financial advisor? Option A. Immediately contact Alabama Adult Protective Services to report a potential case of financial exploitation. Option B. Politely ask Mr. Gable to step out of the room so you can speak with Ms. Gable privately to confirm her understanding and wishes regarding the transfer. Option C. Contact Mr. Gable to discuss Ms. Gable's financial decisions without her explicit consent. Option D. Proceed with the transaction as requested by Mr. Gable, assuming he is acting in his mother's best interest. The correct answer is B. Politely ask Mr. Gable to step out of the room so you can speak with Ms. Gable privately to confirm her understanding and wishes regarding the transfer. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a vulnerable elder, potential undue influence, and conflicting family interests. Financial advisor must navigate these complexities while upholding their fiduciary duty and adhering to Alabama's specific elder law protections and ethical guidelines for financial professionals. Careful judgment is required to ensure the client's best interests are prioritized and that no exploitation occurs. Correct approach analysis. The best professional practice involves immediately pausing the transaction and initiating a conversation with the client, Ms. Gable, in private, away from her son. This approach directly addresses the potential for undue influence by creating a safe space for Ms. Gable to express her wishes freely. It aligns with the ethical obligation to act in the client's best interest and to be vigilant against exploitation, as emphasized by Alabama's laws concerning vulnerable adults and the professional standards governing financial advisors. This proactive step allows the advisor to assess Ms. Gable's capacity and voluntariness without pressure. Incorrect approach is analysis, proceeding with the transaction as requested by the son, without further private consultation with Ms. Gable, would be a significant ethical and regulatory failure. This bypasses the advisor's duty to ensure the client's informed consent and could facilitate financial exploitation, violating Alabama's protections for vulnerable adults. Contacting Ms. Gable's son to discuss her financial decisions without her explicit consent would breach client confidentiality and could escalate the situation, potentially leading to further pressure on Ms. Gable. This action undermines the advisor's fiduciary responsibility to Ms. Gable alone. Immediately reporting the situation to Adult Protective Services without first attempting to ascertain Ms. Gable's wishes and capacity directly, while well-intentioned, might be premature. While reporting is crucial if exploitation is confirmed, the initial step should be to gather information directly from the client in a supportive environment to understand the situation fully. This approach bypasses the advisor's direct responsibility to their client. Professional reasoning. Professionals should employ a decision-making framework that prioritizes client autonomy and protection. This involves 1. Recognizing red flags for potential undue influence or diminished capacity. 2. Creating opportunities for private, unpressured communication with the client. 3. Assessing the client's understanding and voluntariness. 4. Documenting all interactions and decisions meticulously. 5. Consulting with compliance or legal counsel when complex ethical or legal issues arise. 6. Taking appropriate action based on the assessment, which may include reporting to relevant authorities if exploitation is suspected or confirmed. Question 13. The audit findings indicate that a client in Mobile, Alabama, recently made several substantial gifts to their adult children without consulting an elder law attorney. The client is now concerned about their ability to qualify for Medicaid long-term care benefits in the near future. What is the most prudent course of action for an elder law professional to advise in this situation? Option A. Advise the client to immediately consult with an elder law attorney to thoroughly review the details of the gifts, the applicable Alabama Medicaid look-back period, and potential exemptions or strategies to mitigate any adverse impact on future Medicaid eligibility. Option B. Advise the client to simply wait for a period of 5 years, assuming that all issues related to the gifts will be resolved by then under Alabama Medicaid rules. Option C. Advise the client that since the gifts were made to immediate family members, they are automatically permissible and will not affect Medicaid eligibility in Alabama. Option D. Advise the client to attempt to have the gifts returned by the adult children without understanding the potential tax implications or the children's willingness to comply. Correct answer is A. Advise the client to immediately consult with an elder law attorney to thoroughly review the details of the gifts, the applicable Alabama Medicaid look-back period, and potential exemptions or strategies to mitigate any adverse impact on future Medicaid eligibility. Explanation: the audit findings indicate a potential issue with the gifting strategy employed by the client, raising concerns about compliance with Alabama Medicaid regulations and potential implications for long-term care eligibility. This scenario is professionally challenging because it requires balancing the client's desire to transfer assets with the strict rules governing Medicaid eligibility, particularly concerning look-back periods and penalties for uncompensated transfers. Misinterpreting these rules can lead to significant financial hardship for the client, including denial of essential long-term care benefits. The best professional approach involves a comprehensive review of the client's financial situation and the specific details of the proposed gifts in light of Alabama's Medicaid estate planning laws. This includes understanding the look-back period, the definition of an uncompensated transfer, and the potential imposition of a penalty period. A thorough assessment would determine if the proposed gifts are permissible within the statutory framework, considering the client's current and anticipated future needs, and whether any exceptions or exemptions apply. This approach prioritizes client well-being and legal compliance by proactively identifying and mitigating risks before any actions are taken. One incorrect approach involves proceeding with the gifts without a thorough understanding of the Alabama Medicaid look-back period and penalty provisions. This failure to conduct due diligence directly contravenes the professional obligation to advise clients on the legal and financial consequences of their actions. Such an oversight could result in the client being ineligible for Medicaid benefits for an extended period due to an uncompensated transfer, leading to significant out-of-pocket expenses for care. Another unacceptable approach is to assume that any gift made to a family member is automatically permissible without scrutiny. Alabama Medicaid law specifically defines uncompensated transfers and imposes penalties. Ignoring these definitions and proceeding with gifts without verifying their compliance with the law constitutes a breach of professional duty and exposes the client to severe financial penalties. A further professionally unsound approach is to rely solely on general estate planning advice without considering the specific nuances of Alabama's Medicaid eligibility rules. While general gifting principles might be understood, the unique requirements for Medicaid, such as the treatment of transfers for less than fair market value, are critical and must be addressed. Failing to incorporate these specific Alabama regulations into the advice provided is a significant professional failing. Professionals should adopt a decision-making process that begins with a thorough understanding of the client's goals and circumstances. This is followed by a detailed analysis of the relevant Alabama statutes and regulations, particularly those pertaining to Medicaid eligibility and gifting. The professional must then assess the proposed actions against these legal requirements, identify potential risks, and advise the client on compliance strategies that best achieve their objectives while minimizing exposure to penalties. Open and clear communication with the client about the implications of their decisions is paramount. Question 14. The evaluation methodology shows that Mr. Abernathy, a 78-year-old resident of Mobile, Alabama, requires ongoing nursing home care due to advanced Alzheimer's disease. His monthly income from Social Security and a small pension totals $2,100. He owns his home, valued at $150,000, and has $10,000 in a savings account. His daughter, who lives out of state, has inquired about his Medicaid eligibility for long-term care. Which of the following approaches best ensures Mr. Abernathy's potential eligibility is accurately assessed according to Alabama Medicaid regulations? Option A. Advise the daughter that Mr. Abernathy's income is likely too high for Medicaid and that he should explore private pay options or other forms of assistance without a full financial assessment. Option B. Conduct a comprehensive review of Mr. Abernathy's current income, all available assets including the home and savings account, and investigate any asset transfers made within the Alabama Medicaid look-back period to determine his eligibility for long-term care benefits. Option C. Recommend that Mr. Abernathy immediately transfer his home and savings to his daughter to reduce his countable assets below the Medicaid threshold. Option D. Focus solely on Mr. Abernathy's monthly income, as this is the primary factor for Medicaid eligibility in Alabama for long-term care. The correct answer is B. Conduct a comprehensive review of Mr. Abernathy's current income, all available assets including the home and savings account, and investigate any asset transfers made within the Alabama Medicaid look-back period to determine his eligibility for long-term care benefits. Explanation. The evaluation methodology shows that assessing eligibility for Alabama Medicaid requires a nuanced understanding of both income and asset limitations, particularly for individuals seeking long-term care services. This scenario is professionally challenging because it involves a vulnerable population with potentially complex financial situations, requiring careful adherence to Alabama's specific Medicaid regulations to ensure fair and accurate determination of benefits. Misinterpreting these rules can lead to denial of essential care or improper allocation of public funds. The correct approach involves a thorough review of all available financial resources, including the applicant's income, assets, and any transfers of assets made within the look-back period, while strictly adhering to the Alabama Medicaid agency's established guidelines for long-term care eligibility. This approach is correct because it directly addresses the core requirements for Medicaid eligibility in Alabama, which are defined by specific income thresholds and asset limits, as well as rules governing asset transfers designed to prevent individuals from divesting assets to qualify for benefits. By meticulously examining all financial aspects and applying the state's regulations, the applicant's true eligibility can be accurately determined, ensuring compliance with Alabama law and ethical practice. An incorrect approach would be to solely focus on the applicant's current monthly income, without considering their available assets or any recent transfers of assets. This is professionally unacceptable because Alabama Medicaid's eligibility criteria for long-term care are not solely income-based. Asset limitations are equally critical. Failing to assess assets and past transfers ignores significant regulatory requirements and could lead to an inaccurate eligibility determination. Another incorrect approach would be to assume that because the applicant has a diagnosed medical condition requiring long-term care, they automatically qualify for Medicaid. This is professionally unacceptable, as it bypasses the mandatory financial eligibility screening process. Alabama Medicaid requires applicants to meet specific income and asset tests regardless of their medical need. A third incorrect approach would be to advise the applicant to transfer assets to family members immediately to reduce their countable assets, without first conducting a comprehensive analysis of the look-back period and potential penalties. This is professionally unacceptable because Alabama Medicaid has a look-back period for asset transfers, and improper transfers can result in a period of ineligibility for benefits, directly contradicting the goal of securing necessary care. The professional reasoning process for similar situations should involve a systematic evaluation of all eligibility criteria as defined by the Alabama Medicaid agency. This includes a detailed income assessment, comprehensive asset inventory, and a review of any asset transfers within the statutory look-back period. Professionals must prioritize understanding and applying the specific Alabama Medicaid statutes and regulations, seeking clarification from the Alabama Medicaid agency when necessary, and always acting in the best interest of the applicant while upholding regulatory compliance. Question 15. What factors determine Medicare coverage for skilled nursing facility services for an elder residing in Alabama? Option A. The elder's specific medical diagnosis alone guarantees full and unlimited Medicare coverage for any skilled nursing facility stay. Option B. Medicare will cover the entire skilled nursing facility stay as long as the elder has Medicare Part A. Option C. The elder should be admitted to the facility, and Medicare will automatically process and approve coverage based on their enrollment. Option D. Medicare coverage is contingent upon a physician's order, a qualifying inpatient hospital stay, and a determination of medical necessity for skilled nursing or rehabilitative services, with coverage being time-limited and subject to ongoing review. Correct answer is D. Medicare coverage is contingent upon a physician's order, a qualifying inpatient hospital stay, and a determination of medical necessity for skilled nursing or rehabilitative services, with coverage being time-limited and subject to ongoing review. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the complex and often confusing landscape of Medicare coverage for a vulnerable elder. The family's immediate concern and potential lack of understanding of Medicare's intricacies necessitate a clear, accurate, and ethical response. Misinformation can lead to significant financial burdens and unmet healthcare needs for the elder. Professionals must balance providing helpful information with adhering to Medicare regulations and ethical obligations to avoid providing advice beyond their scope or making promises that cannot be kept. Correct approach analysis. The best professional approach involves accurately explaining the general principles of Medicare coverage for skilled nursing facility stays, emphasizing that coverage is not automatic and depends on specific criteria. This approach correctly highlights the need for a physician's order, a qualifying hospital stay, and the determination of medical necessity by Medicare. It also appropriately manages expectations by stating that Medicare coverage is time-limited and subject to review, and that a formal assessment will be conducted. This aligns with the ethical duty to provide truthful and transparent information, empowering the family to understand the process without making definitive pronouncements about coverage that are premature. Incorrect approaches analysis. One incorrect approach is to assure the family that Medicare will cover the entire stay because the elder has Medicare. This is professionally unacceptable because it is a definitive statement of coverage that cannot be made without a formal assessment and adherence to all Medicare eligibility requirements. It misrepresents the conditional nature of Medicare benefits and could lead to the family incurring unexpected costs. Another incorrect approach is to advise the family to simply admit the elder to the facility and let Medicare sort out the coverage later. This is professionally unacceptable, as it bypasses the established Medicare pre-authorization and assessment processes. It demonstrates a lack of understanding of the regulatory framework governing Medicare coverage for skilled nursing care, and could result in the elder or family being responsible for costs that could have been avoided with proper procedural adherence. A further incorrect approach is to suggest that the elder's specific diagnosis automatically qualifies for unlimited Medicare coverage. This is professionally unacceptable because Medicare coverage is based on the need for skilled nursing care and rehabilitation services, not solely on a diagnosis. While a diagnosis might indicate a potential need, it does not guarantee coverage, and the specific circumstances and services required are paramount in the Medicare determination process. Professional reasoning. Professionals should approach such inquiries by first understanding the client's situation and then providing accurate, general information about the relevant program's rules. They should avoid making definitive promises or guarantees about coverage. The decision-making process should involve 1. Identifying the core question, Medicare coverage for skilled nursing. 2. Recalling the fundamental requirements for Medicare coverage in this context, physician order, qualifying hospital stay, medical necessity, skilled level of care. 3. Communicating these requirements clearly and transparently, managing expectations about the conditional and time-limited nature of benefits. 4. Advising the family on the next steps within the established process, e.g., discussing with the physician facility admissions. 5. Recognizing the limits of one's own expertise and referring to appropriate resources or professionals if necessary. Question 16. The control framework reveals that an attorney in Alabama is tasked with drafting a new will for an elderly client who has recently experienced a significant financial windfall. The client's adult children are present during the initial consultation and actively participate in the discussion, expressing strong opinions about how the client's assets should be distributed. The attorney must determine the most appropriate course of action to ensure the client's wishes are accurately and legally documented. Option A. Proceed with drafting the will immediately based on the information provided by the children, assuming the client's agreement due to their presence and apparent acquiescence. Option B. Draft the will based on the consensus of the client's children, as they are likely to know the client's general wishes and can facilitate the process efficiently. Option C. Conduct a private, in-depth interview with the client to assess their mental capacity, understand their independent testamentary intentions, and document these findings thoroughly, while also addressing any potential undue influence concerns. Option D. Delegate the task of assessing the client's capacity and understanding of the will's provisions to one of the client's adult children, who can then relay the information back to the attorney. The correct answer is C. Conduct a private, in-depth interview with the client to assess their mental capacity, understand their independent testamentary intentions, and document these findings thoroughly, while also addressing any potential undue influence concerns. Explanation. The control framework reveals a scenario that is professionally challenging due to the inherent vulnerability of an elder client and the potential for undue influence or diminished capacity to impact their testamentary wishes. Careful judgment is required to ensure the client's autonomy is respected while also safeguarding against exploitation and ensuring the validity of the will under Alabama law. The best professional approach involves a thorough assessment of the client's mental capacity and the absence of undue influence. This includes engaging in direct, private conversations with the client to ascertain their understanding of the will's provisions and their independent desires. Documenting this assessment meticulously, including observations about the client's demeanor, clarity of thought, and any potential external pressures, is crucial. This aligns with the ethical obligations of an attorney to represent their client competently and diligently, ensuring the client's wishes are accurately reflected and legally sound, as per Alabama rules of professional conduct regarding client representation and capacity. An approach that involves solely relying on the family's input regarding the client's wishes without independent verification of the client's capacity and intent is professionally unacceptable. This failure to directly assess the client's understanding and volition could lead to a will that does not reflect the client's true desires, potentially violating the client's autonomy and opening the door to challenges based on undue influence or lack of testamentary capacity under Alabama probate law. Another professionally unacceptable approach is proceeding with drafting the will based on a family member's summary of the client's wishes without any direct communication or assessment of the client themselves. This bypasses the fundamental requirement of attorney-client communication and fails to establish the client's independent intent, risking the creation of an invalid will and violating ethical duties of diligence and communication. Finally, an approach that prioritizes the convenience of the family over the client's direct involvement and independent decision-making is also professionally unsound. While family involvement can be helpful, the attorney's primary duty is to the client. Failing to ensure the client's direct and informed consent to the will's provisions, even if it means delaying the process or managing family expectations, is a breach of professional responsibility. The professional decision-making process for similar situations should involve a tiered approach. First, assess the client's capacity and identify any potential red flags for undue influence. Second, engage in direct, private communication with the client to understand their wishes and ensure they comprehend the implications of their decisions. Third, document all interactions and assessments thoroughly. Fourth, if capacity or undue influence is a significant concern, consider involving a neutral third party or seeking a judicial determination of capacity. Finally, always prioritize the client's best interests and autonomy above all else, adhering strictly to Alabama's legal and ethical standards. Question 17. Market research demonstrates that many seniors in Alabama are concerned about preserving their assets while planning for potential long-term care needs. A client, who is a resident of Alabama and has significant assets, expresses a desire to implement strategies to protect these assets from depletion due to future healthcare costs and potential creditors. What is the most prudent and legally compliant course of action for a professional advising this client? Option A. Advise the client to immediately transfer all assets to their children to shield them from future expenses and creditors, without further investigation into Alabama's specific transfer laws. Option B. Conduct a thorough assessment of the client's financial situation, long-term care needs, and specific goals. Then discuss legitimate asset protection strategies available under Alabama law, such as irrevocable trusts, gifting with consideration for look-back periods, and utilizing Alabama's homestead exemption, ensuring the client understands all implications. Option C. Recommend placing all assets into a revocable trust, explaining that this will automatically protect them from creditors and future healthcare costs without needing to consider specific Alabama statutes. Option D. Suggest making large, immediate cash gifts to various family members without regard for Medicaid look-back periods or the potential for these transfers to be deemed fraudulent under Alabama law. The correct answer is B. Conduct a thorough assessment of the client's financial situation, long-term care needs, and specific goals, then discuss legitimate asset protection strategies available under Alabama law, such as irrevocable trusts, gifting with consideration for look-back periods, and utilizing Alabama's homestead exemption, ensuring the client understands all implications. Explanation. This scenario presents a professional challenge because it requires balancing a client's desire for asset protection with the ethical and legal obligations to avoid fraudulent conveyances, and to ensure the client understands the implications of their decisions, especially given their age and potential vulnerability. The professional must navigate the complexities of Alabama law concerning transfers of assets intended to defeat creditors or qualify for government benefits. The best approach involves a comprehensive assessment of the client's current financial situation, their long-term care needs, and their specific goals, followed by a discussion of legitimate asset protection strategies permissible under Alabama law. This includes exploring options like irrevocable trusts, gifting strategies with consideration for look-back periods, and the use of Alabama's homestead exemption, all while ensuring the client fully comprehends the limitations and potential consequences of each strategy. This approach is correct because it prioritizes informed consent, adherence to Alabama statutes governing asset transfers, and the avoidance of actions that could be construed as fraudulent. It aligns with the ethical duty to provide competent advice and to act in the client's best interest within legal boundaries, an approach that focuses solely on transferring assets to family members without considering the potential for these transfers to be deemed fraudulent conveyances under Alabama law is incorrect. Alabama law, like most states, has provisions to invalidate transfers made with the intent to hinder, delay, or defraud creditors. Such an approach would expose the client and potentially the professional to legal repercussions. Another incorrect approach would be to advise the client to transfer all assets into a revocable trust without fully explaining the implications for Medicaid eligibility and creditor protection. Revocable trusts generally do not offer asset protection from creditors or for long-term care planning purposes, as the grantor retains control and access to the assets. This would fail to meet the client's underlying asset protection goals and could lead to significant financial detriment. Finally, recommending immediate, large lump sum gifts to children without considering the Medicaid look-back period or the potential for these gifts to be challenged as fraudulent is also professionally unacceptable. Alabama's Medicaid program has specific rules regarding asset transfers and divestment penalties, and failing to account for these can result in ineligibility for essential long-term care benefits. The professional decision-making process should begin with a thorough client intake, including a detailed financial inventory and a clear understanding of the client's objectives and concerns. This should be followed by research into the specific asset protection tools available and permissible under Alabama law, with a particular focus on how these tools interact with state and federal benefits programs like Medicaid. The professional must then clearly communicate the risks, benefits, and limitations of each strategy to the client, ensuring they can make an informed decision. Ethical considerations, such as avoiding conflicts of interest and ensuring client capacity, are paramount throughout the process. Question 18. Market research demonstrates that many individuals seeking assistance with Alabama Medicaid applications for long-term care face challenges due to incomplete or inaccurate documentation. A professional assisting an elder client in Alabama is preparing to submit a Medicaid application. Which of the following actions best represents a proactive and compliant approach to navigating the Alabama Medicaid application process? Option A. Advise the elder to transfer significant assets to immediate family members to reduce countable resources, assuming this will expedite eligibility. Option B. Meticulously gather and verify all required financial, medical, and residency documentation, ensuring its accuracy and completeness according to Alabama Medicaid agency guidelines before submitting the application. Option C. Submit the initial application with readily available documents and plan to provide any missing information as requested by the Alabama Medicaid agency. Option D. Rely on the elder's verbal statements about their income and asset holdings, as they are generally trustworthy. The correct answer is B. Meticulously gather and verify all required financial, medical, and residency documentation, ensuring its accuracy and completeness according to Alabama Medicaid agency guidelines before submitting the application. Explanation. This scenario is professionally challenging because navigating the Alabama Medicaid application process for an elder requires a delicate balance of advocating for the client's needs while strictly adhering to complex and often unforgiving regulatory requirements. Missteps can lead to significant delays, denial of benefits, and financial hardship for the elder. Careful judgment is required to ensure all documentation is accurate, timely, and compliant with Alabama Medicaid's specific rules regarding asset limits, income, and transfer of assets. The best professional approach involves proactively gathering all necessary documentation, including proof of income, assets, medical expenses, and residency, and meticulously reviewing it for accuracy and completeness before submission. This approach prioritizes thoroughness and compliance, minimizing the risk of application rejection due to missing or incorrect information. Alabama Medicaid regulations, such as those outlined in the Alabama Medicaid Agency's policies and procedures, emphasize the importance of complete and accurate applications for timely processing and eligibility determination. By taking these proactive steps, the professional demonstrates due diligence and a commitment to securing the elder's benefits efficiently and ethically. An incorrect approach would be to submit an incomplete application with the intention of providing missing information later. This fails to meet the Alabama Medicaid agency's requirements for a fully documented application at the point of submission. Such an action can lead to delays and potential denial, as the agency may close the application if critical information is not provided within their specified timeframes. Another incorrect approach is to advise the elder to transfer assets to family members without fully understanding Alabama's look-back period and penalty provisions for asset transfers. This directly violates Alabama Medicaid's rules designed to prevent individuals from divesting assets solely to qualify for long-term care benefits. Failure to adhere to these transfer of asset rules can result in significant ineligibility periods, leaving the elder without necessary care. Finally, an incorrect approach is to rely solely on the elder's verbal assurances regarding their financial situation without obtaining supporting documentation. Alabama Medicaid requires verifiable proof of all financial information. Relying on verbal statements alone is insufficient and can lead to an inaccurate application, ultimately jeopardizing the elder's eligibility. Professionals should employ a systematic decision-making process that begins with a thorough understanding of the client's circumstances and a deep dive into the current Alabama Medicaid eligibility rules. This should be followed by a meticulous checklist approach to documentation gathering, a clear communication strategy with the client and their family, and a final review of the entire application package for compliance before submission. When in doubt about specific regulations, consulting official Alabama Medicaid agency resources, or seeking guidance from experienced elder law attorneys specializing in Alabama Medicaid is crucial. Question 19. The evaluation methodology shows that a resident of Alabama dies intestate, leaving a surviving spouse and 2 children from a previous marriage. What is the most appropriate professional action to take regarding the distribution of the deceased's estate under Alabama law? Option A. Facilitate an informal agreement among the surviving spouse and children based on their perceived wishes, bypassing formal legal distribution. Option B. Distribute the entire estate to the 2 children from the previous marriage, as they are the direct descendants of the deceased. Option C. Assume the surviving spouse inherits the entire estate, as they were married at the time of death. Option D. Ascertain the exact composition of the estate and apply the provisions of Alabama Code Title 43, Chapter 8, to determine the respective shares of the surviving spouse and the children from the previous marriage. The correct answer is D. Ascertain the exact composition of the estate and apply the provisions of Alabama Code Title 43, Chapter 8, to determine the respective shares of the surviving spouse and the children from the previous marriage. Explanation. Scenario analysis. This scenario presents a professional challenge because it involves navigating the complexities of intestate succession in Alabama, specifically when a deceased individual leaves behind a spouse and children from a previous marriage. The challenge lies in accurately applying Alabama's statutory framework to determine the distribution of the estate, ensuring fairness to all potential heirs while adhering strictly to legal requirements. Misinterpreting these laws can lead to significant legal disputes, financial hardship for beneficiaries, and potential professional liability. Correct approach analysis. The best professional approach involves a thorough review of the deceased assets and liabilities, followed by a precise application of Alabama Code Title 43, Chapter 8, Descent and Distribution. This code specifically outlines how an estate is divided when there is no valid will. For a surviving spouse and children from a prior marriage, Alabama law generally provides the surviving spouse with a portion of the estate, and the remainder is distributed among the children. The critical step is to identify whether the children are solely the deceased's children, or if they are children of the surviving spouse from a previous marriage, as this distinction can impact the distribution. The professional must meticulously identify all legal heirs and their respective shares as dictated by the statute, ensuring all legal formalities are met for the probate process. Incorrect approaches analysis. One incorrect approach would be to assume that the surviving spouse automatically inherits the entire estate, regardless of the existence of children from a previous marriage. This fails to recognize Alabama's specific intestate succession laws, which protect the inheritance rights of children. Another incorrect approach would be to distribute the estate solely among the children without considering the surviving spouse's statutory rights. Alabama law grants specific rights to a surviving spouse in an intestate estate, and ignoring these rights is a direct violation of the law. A third incorrect approach would be to rely on informal family agreements or perceived intentions of the deceased without consulting the Alabama Code. While family harmony is important, legal distribution must be based on statutory mandates, not on informal understandings, especially in intestate matters where the law provides a clear framework. Professional reasoning. Professionals facing such situations must adopt a systematic approach. First, gather all relevant information about the deceased, their family structure, and their assets. Second, consult the governing statutes of Alabama, specifically Title 43, Chapter 8, to understand the precise rules of intestate succession. Third, identify all legal heirs and their statutory entitlements. Fourth, communicate clearly and transparently with all parties involved, explaining the legal process and the basis for the proposed distribution. Finally, ensure all actions are documented and comply with probate court procedures. Question 20. Governance review demonstrates that Mr. Abernathy, a resident of Mobile, Alabama, requires long-term skilled nursing care. His Medicare benefits for skilled nursing care will exhaust in 30 days. His total countable assets are $50,000, and his wife, Mrs. Abernathy, remains in their home with a monthly income of $2,500. The current minimum monthly maintenance needs allowance, MMMNA, for Alabama is $3,715.50 per month. The Alabama Medicaid asset limit for an institutionalized individual is $2,000. Assuming the nursing home costs $8,000 per month, what is the most accurate calculation of Mr. Abernathy's spend-down requirement to qualify for Medicaid long-term care benefits after his Medicare coverage ends? Option A. Mr. Abernathy's countable assets are $50,000. The Medicaid asset limit is $2,000. Therefore, the spend-down is $50,000. $2,000 equals $48,000. Mrs. Abernathy's income is not relevant to Mr. Abernathy's spend-down calculation. Option B. Mr. Abernathy's countable assets are $50,000. Since Mrs. Abernathy's income is $2,500 and the MMMNA is $3,715.50, the difference of $1,215.50 is added to the $2,000 asset limit, resulting in a total of $3,215.50 that can be retained. Therefore, the spend-down is $50,000, $3,215.50 equals $46,784.50. Option C. Mr. Abernathy's countable assets are $50,000. The nursing home costs $8,000 per month. After 30 days of Medicare coverage, the remaining cost is $6,000. This $6,000 is the spend-down requirement. Option D. Mr. Abernathy's countable assets are $50,000. After subtracting the $2,000 Medicaid asset limit, he has $48,000 to spend down. Since Mrs. Abernathy's income is below the MMMNA, the difference of $1,215, $50,315, $50,2,500 is added to the spend down, making the total spend down $49,215, $50. The correct answer is D. Mr. Abernathy's countable assets are $50,000. After subtracting the $2,000 Medicaid asset limit, he has $48,000 to spend down. Since Mrs. Abernathy's income is below the MMMNA, the difference of $1,215, $50,315, $50,2,500 is added to the spend down, making the total spend down $49,215, $50. Explanation: this scenario presents a common challenge for elder law professionals in Alabama, accurately calculating the financial eligibility for Medicaid long-term care benefits while accounting for the nuances of Medicare coverage and potential spousal impoverishment protections. The professional must navigate complex federal and state regulations, ensuring the applicant's assets are correctly assessed and that the community spouse's needs are met. The primary difficulty lies in the interplay between Medicare, which covers skilled nursing care for a limited period, and Medicaid, which provides long-term custodial care. Miscalculation can lead to denial of benefits, causing significant financial hardship for the applicant and their family, or improper allocation of resources. The correct approach involves a meticulous calculation that first determines the applicant's countable assets after applying the minimum monthly maintenance needs allowance, MMMNA, for the community spouse, if applicable, and then subtracting the applicant's available assets from the Medicaid asset limit for an institutionalized individual. This approach is correct because it directly adheres to the Alabama Medicaid Agency's eligibility rules for long-term care, which require a thorough assessment of both the institutionalized individual's assets and the community spouse's financial needs to prevent spousal impoverishment. Specifically, Alabama follows federal guidelines for the MMMNA, which is adjusted annually and has its own asset limits for institutionalized individuals. The calculation must also consider the spend down of excess assets to meet the Medicaid limit. An incorrect approach would be to simply subtract the Medicare coverage period from the total cost of care and assume the remaining balance is the Medicaid-eligible amount without a proper asset assessment. This fails to acknowledge that Medicaid eligibility is primarily asset-based, not solely cost-based, and ignores the critical step of evaluating the applicant's and community spouse's financial resources. Another incorrect approach would be to disregard the MMMNA and only consider the applicant's assets against the institutionalized individual limit. This violates the spousal impoverishment provisions designed to protect the financial well-being of the spouse remaining in the community. Finally, an approach that includes non-countable assets, such as the primary residence, under certain conditions, or certain vehicles, in the calculation of excess assets would lead to an inaccurate determination of eligibility. Professional decision-making in such situations requires a systematic process. 1. Identify all relevant financial resources of both the institutionalized individual and the community spouse. 2. Determine the applicable MMMNA for the community spouse based on current Alabama guidelines. 3. Calculate the community spouse's available income and assets to see if they meet the MMMNA. 4. Identify the applicant's countable assets and subtract any protected assets, e.g., homestead certain vehicles. 5. Compare the applicant's remaining countable assets to the Alabama Medicaid asset limit for institutionalized individuals. 6. If assets exceed the limit, determine the amount that must be spent down to achieve eligibility. 7. Factor in any Medicare coverage to understand the transition to Medicaid, but do not let it dictate the initial asset eligibility calculation.